Court of El Paso County, Texas, 409th Judicial District, the state of Texas versus Daniel Villegas, number 94-0D09328. Verdict Form B. We, the jury, find the defendant Daniel Villegas not guilty of...
Imagine reading a court judgment and suddenly the judge makes a profound statement that catches your attention, but is not directly related to the case. Is it legally binding or just an opinion? That is the fascinating concept of Obiter Dictum. And in today's video, we are going to consider what we mean when we say Obiter Dictum in law or Ratio Decidendi. Actually, Obiter Dictum simply means a comment by the wayside or thing said by the way. When you are reading a judgment, you will be presented with the fact of the case. And after going through the fact of the case, you begin to see the judgment of the various justices, especially if the matter is on appeal. And of course, most often, a case that is being reported are the one that has gone beyond trial court, court of appeal, and probably the Supreme Court. So, for instance, if it is a case that is being addressed by the Supreme Court, you have about 5 justices addressing that very case. And if it is a case that has to do with the constitutional right of an individual or something like that, you will see we have about 7 justices deciding that matter on Supreme Court. So these 7 justices will be giving their opinions. They will be giving their judgment. On that very judgment, one person will be the person that will read the lead judgment. Then the whole combined judges or the whole panel of the judges are bound to also give their own judgment. So most of the times, some of them will concur to the lead judgment without providing additional framework to it. Sometimes also, you see some of the judges also elaborating their points, enunciating their own judgment, either in support or dissenting. So we say that a judge is concurring when he's actually giving a judgment that is in support of the lead judgment, which is read by only one judge. Then you say that a judge is dissenting when he's giving a judgment that is contrary to that which has been read by the lead judgment. I believe you are flowing. I'm trying to explain to you what Obiter Dictum means when you say Obiter Dictum. So Obiter Dictum is that part of judgment that is actually not binding, but is still very important and very persuasive. I will give you an instance. In the case of Kalili vs. Carbolic Smoke Ball, if you are not a contract law student, if you have not reached your second year, don't bother yourself much, but you believe me, you are going to see this case when you reach your second year or when you are offering contract law, depending on the institution of the world you are watching this video from. The case of Kalili and Carbolic Smoke Ball Company is a very locus classicus in law of contracts, which established the past that an offer can be made to the world. So when you get to that case of Kalili, you will see that the case was read by the 3 justices, Justice Bowen, Justice Lidley, and that of Justice Smith. Then the lead judgment was read by Justice Lidley. Lidley was the person that enunciated the whole principles that an offer can be made to the whole world. Then in that very case, the ratio of that very case was that actually you can make an offer to the whole world, and provided that anybody who fulfills the conditions of that your offer becomes the right party that you have a contract with. Then in that very case, I will not provide you with the fact of this case because we are not dealing with contract law. But it is a case that simply has to do with how an offer can be made to the whole world and the validity of a contract as an element of contract when it has to do with offer and acceptance. So in that case, the other justices and also the Justice Leader who read the judgment dwelled so much in talking about how an advertisement could either be a binding or can either be a binding on those making the advertisement and also not being a binding to those making the advertisement. If you read that judgment, you will see that they said a lot of things. They said many things. But after everything all said and done, the whole holding of the court was that an offer can be made to the whole world. And anybody who fulfills the conditions, anybody who meets the requirement by furnishing a consideration, then becomes the right party the person has contracted with. So the whole thing that was saying in that case, the ratio is this thing. Any other thing that has no bearing or any other thing that is not typically the reason why the court says that this thing is black, this thing is blue, is considered as Obiter Dictum. I want you to get this point. I don't actually want to bore you with cases Because probably if you are watching this, you could also be a beginner in legal method. So going extra mile into cases will conflict what you are going to understand. But I want you to know is that Obiter Dictum is nothing other than what the judge say by the way. It actually has no direct bearing or relationship to the matter at desk. So if I have give you an instances, if the judges are deciding, if the matter is on appeal, 3 justices if it's got to do with Court of Appeal, 5 justices or 7 if it has to do with Supreme Court, then the whole judges is going to give their decision. They are going to pen down their decision. If you read law report, you will see their various decisions. Then they will say a lot of things. They will divert, they will tell this. All those things they are saying is to support their judgment, is to support why they say that actually Mr. A, the plaintiff, won this matter. Or actually, Mr. the defendant is not liable for this very offense. They would say a lot of things, but at the end, that very thing that makes them say, I thereby hold that this or that becomes the ratio. Other things is considered as Obiter Dictum. So today I want you to see Obiter Dictum as a comment by the wayside, as something the judge say in support of the main judgment. Now, what is the efficacy of Obiter Dictum? I want you to know that actually, in as much as we claim or we say that Obiter Dictum is a comment by the wayside, it still has a force, it still has a solid background in support of a case, because Obiter Dictum is something that has the joy to drive home his judgment, to drive home his point on why he holds that this is this or this is that, either on point of law or on point of fact. Either if he's asserting it on point of law, stating that according to section 11, the law is supreme, and every other law which is in consistency with the supremacy of the Constitution is null and void to the extent of its inconsistency, there must be something he would have said to allow him or to drive home that point that the law is supreme. All other things are considered as Obiter Dictum. And if the court then relies on the virtue of sections 1 sub 3 of the 1999 Constitution to arrive at or to conclude on a particular point of law that this is this is that, that becomes the ratio. Any other thing he says, any other thing he tries to put up his judgment to flow becomes Obiter Dictum. I hope someone is getting my point. Do you get my point? Now, another also case I want to give as an example, it is also a notable case in all common law jurisdiction, is the case of Donnell v. Stevenson. In the case of Donnell v. Stevenson, Lord Atkin established what we now call today as neighborhood principle in law. And basically, it is a locus classicus in law of tort, which established the principles of negligence and the duty of care, as well as the principles of neighborhood doctrine. So in this very case now, the court held that your neighbor is anybody that has a direct bearing to your act or your consequence. So any person in this world, his neighbor is not only by proximity, somebody you are living close with in your yard, but anybody who will come in contact with your actions or inaction becomes your neighbor in law. It is the locus classicus in law of tort as far as negligence is concerned. In that very case, Lord Atkin, to drive home his point of neighborhood principle, said a lot of things. According to Lord Atkin, in that case, he alluded to the scripture by saying that you ought to love your neighbor as stated by Jesus Christ. Simply means that you ought to take a reasonable care not to injure your neighbor. Lord Atkin said a lot of things to drive home his point of establishing the neighborhood principle. Whatever the erudite Lord Atkin has said in that case, that helps him to come to the conclusion of neighborhood principle becomes the Obiter Dictum. And the ratio decidendi of that case is that any person that has the direct bearing to your consequence or your act, your inaction, has become your neighbor, regardless of whether the person is close to you or not. So once somebody comes in contact with your action and is affected, you owe that person the duty of care. You may not understand this until you punctuate on a lot of thoughts, but believe me when I say that your understanding of Obiter Dictum should simply be that any other thing the court say without actually being the reason why he decided this or that, but to support his analogy becomes the Obiter Dictum. Then the other one that is the main fulcrum upon which the judgment is built becomes the ratio decidendi. And in my next video, we are going to discuss something that has to do with finding the ratio decidendi of a case, because it is important, not because you are a future lawyer to be, but simply because in your exam you are going to be presented with a hypothetical case or fact, and it is left for you to read the whole structure of that very question to actually see what is needed of you in that very question. The lecturer is going to say a lot of things. The lecturer is going to bamboozle you and confuse you with a lot of scenario, example, just a lot of irrelevant things. But at the end, there is a reason or there is thing the lecturer wants you to pick. That thing for me is what I will be doing like this. When I have my paper, I'll be underlining all of it. If I read this, I underline. I read this, I underline. If you see my paper after coming out from example, you are going to see how I cancelled, how I underline a lot of things. All those things I underline for me is the ratio. Any other thing the lecturer is saying, any other thing he's yarning is not for me. It's just yarning or pattern. What I know is that very thing that is needed. And once you underline it, it is that place you are going to apply your IRAC, your IPAC, your everything you use to answer your problem question to actually do justice to it. And that also remind me, next week also we will also make a video that has to do with how to answer problem question. Please subscribe to King's Advocate, because here on this channel we dwell much on helping you to understand the things that you could ordinarily find very hard to understand when your lecturer is teaching or when your lecturer have taught you that very topic. So subscribe to this channel, because next week we are going to also talk more on this. Remain blessed and thanks for watching this video. Remember to share with your friend, and I believe this video helps. Like this video and also check my video that has to do with essential basic term that all law students will know. Thank you and remain blessed.